Okay, welcome back to this year's annual conference. I hope you had time to grab a coffee. First of all, I would like to thank the speakers and everybody who contributed to the interesting discussion on the Digital Markets Act. In session 2, we will now switch topics and move on to the Digital Services Act. It is quite safe to say that the e-commerce directive's liability exemptions for intermediary services have influenced the way we experience the internet today. So what is new, what is going to change, and what will stay the same under the Digital Services Act? This question will be answered by Christoph Busch and Vanessa Mark, two esteemed legal experts in the field of platform regulation. Christoph Busch is a professor at law and the director of the European Legal Studies Institute at the University of Osnabrück. We'll start off this session and focus on Articles 3, 4, and 5 of the Digital Services Act. As a member of the expert group to the EU Observatory on the Platform Economy and project reporter to the European Law Institute's Model Rules on Online Platforms, Christoph Busch has and still is shaping legal thinking regarding the platform economy. In the second presentation of this session, Vanessa Mark, also professor of law and vice dean for research at the Tilburg Law School, will examine Articles 6 to 9. Vanessa Mark has an impressive academic record in the field of European private law, and in several reports for the European Parliament and Commission, she has researched issues of consumer law in the digital economy. Vanessa Mark was also a project team member of the ELI's Model Rules on Online Platforms. We feel very privileged that Vanessa Mark and Christoph Busch have agreed to share their views on the liability framework under the DSA at today's conference. Last but not least, I would also like to introduce Jan Penfrat. Being a senior policy advisor at European Digital Rights in charge of platform regulation and online disinformation makes him a perfect candidate to moderate this session. But enough of a preamble, I would now like to give the digital floor to Professor Christoph Busch. The floor is yours.
Thank you very much. I will try to share a presentation which seems to work. So first of all, I would like to thank the organizers for inviting me to this conference. I have been asked to speak about Articles 3 to 5 of the DSA proposal, which grant conditional liability exemptions to certain providers of online intermediary services. That's a huge topic, and it's probably fair to say that the safe harbor framework for intermediaries is one of the core pillars of internet regulation in the European Union. Discussing intermediary liability in just 20 minutes is a daunting task, and I will certainly not be able to cover the entire topic in all its details. So I will not cover fake news, hate speech, unsafe products. I will rather focus on one important aspect, which I think so far has been a little bit neglected in the discussion, and that is what will Article 3 to 5 mean for online marketplaces and in particular consumer safety on online marketplaces. I will do this in 4 quick steps, which you can see here. First, I will give a very brief overview of the new liability framework, and we will see it's not so new after all. Second, I will address what might be termed a cautious codification of the case law of the Court of Justice of the European Union. Third, something new, the introduction of the average consumer test for intermediary liability in Article 5, paragraph 3. And then at the end, I will ask what is missing in the DSA proposal, at least from my perspective. So let's start with an overview. The liability framework of the DSA is very similar, very much resembles the model of the e-commerce directive. It's a horizontal framework of conditional exemptions from liability. And Article 3 to 5, that's important to underline again, only establish situations in which intermediaries are not liable for third-party content or illegal activity, they do not provide a positive basis for establishing when a service provider could be held liable. As the e-commerce directive, the DSA specifically addresses three kinds of services: mere conduit service, such as internet access providers; caching service, such as caching proxy services; and hosting services, such as social media platforms and online marketplaces. The provisions on mere conduit and caching have been copied verbatim from the e-commerce directive. So there's nothing new in the text. The only difference is that they are now contained in a regulation, not a directive, which of course increases the level of harmonization here. There's some new elements in Articles 6 and 7, which I will not address, as Vanessa will talk about this later. So I will focus mainly on Article 5, which in my view merits some closer inspection. Article 5 contains, as I said, the safe harbor for hosting services. Under this rule, a hosting service provider is not liable for information stored at the request of a user, subject to two alternative conditions. First, if the provider does not have actual knowledge of illegal activity or illegal content, and as regards claims for damages, is not aware of facts or circumstances from which the illegal activity or illegal content is apparent. Second, if the provider, upon obtaining such knowledge or awareness, acts expeditiously to remove or disable access to the illegal content. So, to put simply, the DSA adheres to the information, to the knowledge-based liability framework of Article 14 of the e-commerce directive. There's also nothing new here. According to the well-established case law of the European Court of Justice, the applicability of the safe harbor provisions depends on whether the intermediary has played a neutral role or passive role on the one hand, or an active role on the other hand. This neutrality or passivity requirement stems from recital 42 of the e-commerce directive. And in the cases Google France and L'Oréal against eBay, the Court of Justice has stated that the liability exemptions do not apply to service providers who play an active role that would give the provider knowledge or control over the activity or information that it has hosted. This well-established case law is now codified in recital 18 of the DSA. But surprisingly, the DSA makes no effort to set out any criteria how to distinguish between active or passive services. So the DSA remains somewhat static in this respect. The same is true for Article 5, Para 2 DSA, which states that the liability exemption does not apply to cases where the illegal content has been provided by a user who is acting under the authority or the control of the provider. This is also almost verbatim from Article 14 DSA, e-commerce directive. Now, Article 5, Para 3 brings a new element, brings an addition. With respect to liability of online marketplaces under consumer protection law, this authority or control standard of Article 5, Para 2 is modified. And that's probably one of the most interesting additions that the DSA brings to the liability framework. According to this provision, the liability exemption does not apply with respect to liability under consumer protection law of B2C marketplaces if the design of the marketplace leads an average consumer to believe that the information or products are provided by the marketplace operator itself, or a third party acting under its authority or control. So Article 5, Para 3 makes clear that the application of the liability exemptions in this scenario very much depends on how the online marketplace presents itself towards consumers. So you could say, when it comes to liability of online marketplaces, it's all about appearances. And as we know, appearances can be deceptive. The provision essentially addresses two different scenarios regarding online marketplaces. In the first scenario, the platform operator itself appears to be the seller or the supplier. This situation is somewhat similar to the well-known Vatele case of the Court of Justice, which concerned the owner of a garage acting as an offline intermediary for the sale of a used car between two consumers. According to the Court of Justice, the intermediary in Vatele can be held liable as a seller for the purposes of the Consumer Sales Directive if it, and now I quote, creates confusion in the mind of the consumer by giving him the false impression that he is acting as the seller of the goods. So it's about appearances, about how the intermediary appears in the view of the consumer. A similar reasoning was recently applied by the Advocate General Sorgmannsgaard Ö in the YouTube case. And according to the Advocate General, a provider plays an active role and leaves the liability-free zone if it presents information to the public in such a way that it appears to be its own. In other words, when it appropriates that information. This seems very much in line with the German case law, according to which adopted content, zu eigen gemachte Inhalte, are treated as the intermediary's own content. So that is the first scenario that is addressed by Article 5, Para 3 DSA. The second scenario, this one, is not about lack of transparency of contractual role, but rather about something that could be termed apparent control. In this scenario, it is clear that the information or the products are not provided by the platform operator, but the platform operator appears to exercise control over the third-party supplier. This scenario somewhat resembles to the approach taken by Article 20 of the European Law Institute's Model Rules on Online Platforms, which impose a liability on platform operators if, and here you can see the text, if the customer can reasonably rely on the platform operator having a predominant influence, or you might say control, over the supplier. There is, of course, a very important difference between Article 20 and Article 5, Para 3. Article 20 of the EDRi Model Rules provides a positive basis for liability. Article 5, 3 DSA only takes away the liability exemption. But both provisions share the common idea that an apparent control affects intermediary liability. Now, for the sake of legal certainty, it might have been helpful to add a list of indicative criteria that will be taken into account for determining whether a marketplace operator appears to exercise control over third-party sellers. In this perspective, a source of inspiration for further developing this provision could be Article 20, Para 2 of the EDRi Model Rules on Online Platforms, which does contain such a list of indicative criteria for determining whether a consumer can reasonably rely on the platform operator's predominant influence. I have just given some examples from the longer list. And according to this provision, the liability of the platform operator depends, among other elements, on whether the terms of the contract concluded between the consumer and the third-party supplier are essentially determined by the platform operator. Another aspect to be taken into account is whether the platform operator exclusively uses payment systems which enable the platform operator to withhold payments made by the consumer to the supplier and thus exercise control, exercise influence over the supplier. In addition to this, there are some more open questions regarding Article 5.3. I will just mention two of them. First, what exactly does the provision mean by liability under consumer protection law? Recital 10 of the DSA refers to several directives, such as the Unfair Terms Directive, the Unfair Commercial Practices Directive, and the Consumer Rights Directive. But what about other areas of consumer law, such as the Product Liability Directive, for example? Does the average consumer test also apply to the question whether an online marketplace can be held liable for damages caused by a defective product? The second question that I would like to raise relates directly to the average consumer test itself. How flexible is this test? As you know, the Unfair Commercial Practices Directive contains not just the average consumer test, but also a specific rule for vulnerable consumers. Should the same differentiated test also apply here in Article 5, Para 3? Let me finish with a few quick remarks on what I think is missing in the DSA proposal. Here are again only two examples or two elements that could be food for further thought. The first is about links between the due diligence obligations in Chapter 3, that we will hear more about in the next session, and the liability exceptions in Chapter 2. At the moment, there is no clear link between these two pillars of the DSA proposal. Take, for example, Article 22 DSA, which requires operators of online marketplaces to take reasonable efforts to verify the identity of traders, the so-called Know Your Business Customer Rule, or KYBC rule. What happens if a marketplace operator violates its duty to verify? The DSA provides for administrative sanctions, public enforcement. But this approach does not help a consumer who buys a dangerous product from an untrustworthy marketplace seller and suffers a damage and is unable to sue the marketplace seller because the marketplace operator has not verified the seller's identity and cannot provide contact details of this untrustworthy seller. In such a case, it seems reasonable to me that the marketplace operator's failure to verify the seller's identity should result in a loss of the liability exemption. In other words, the DSA should combine public enforcement and private enforcement of the due diligence obligations. On the slide, you can see how such a provision linking Article 22 and Article 5 DSA could look like. I would suggest a new Para 3A for Article 5 DSA. And then, of course, there is the elephant in the room, as I would put it. Liability of online marketplaces that have predominant influence over suppliers, and essential elements of the economic transaction. In October last year, the European Parliament suggested that the DSA should address this issue with regard to cases where no other actor in the EU can be held liable. However, the European Commission chose not to follow this suggestion. In the staff working document that accompanies the DSA proposal, the Commission explicitly refuses to address this issue in the DSA, arguing that this is a sector-specific concern that has no place in a piece of horizontal legislation that only addresses exemptions of liability. It is true that imposing a specific liability for online marketplaces would deviate from the concept of harmonizing only liability exemptions in the DSA. So from a strict conceptual perspective, it's right not to address positive liability rules in the DSA. But at the same time, there's a pressing need to answer the question under which conditions an online marketplace can be held liable for defective products. In this respect, the EU is lagging behind recent developments in the United States, where an appeals court in California decided in Bolger against Amazon that Amazon can be held liable for injuries caused by defective products, in that case, an exploding laptop battery, sold by a third-party seller on the Amazon marketplace. How would this case be dealt with in Europe? Well, a number of questions arise. Can Amazon be qualified as an importer under the Product Liability Directive? Will the answer be different depending on whether we have a fulfillment by Amazon case or a direct shipping case? And does the e-commerce directive or a future DSA shield Amazon from product liability in such a case? In the US, the courts are split on the question whether Section 230 of the Communication Decency Act shields online marketplaces against product liability. It seems that a majority of courts more recently seem to answer this question in the negative, but it's not yet settled. And it's not even discussed, I would say, in depth in Europe. I have no time to answer all these questions here, but there are some further readings for those who want to dig deeper into the question of liability of online marketplaces, and maybe we can address some of these questions in the discussion. Thank you very much.
Thank you very much, Professor Busch. This was very interesting, and thank you for sharing your thoughts on this particularly interesting article, Article 5, Paragraph 3. Without much delay, I want to hand over to Vanessa Mark, who is a professor at the Leiden University, and she will continue with her views and share her thoughts on the remaining provisions of Chapter 2 of the Digital Services Act. And the floor is yours, Vanessa Mark.
Thank you very much, Yannic, and also for mentioning that I'm now at Leiden University. I moved there 1st of October, but apparently my webpage at Tilburg is still on air. And I guess I'm still sitting at the same kitchen table, so in that respect, nothing much has changed. But it is a big change nonetheless. Right, so now the Digital Services Act. I'm going to share my screen with you. And I'm going to follow up on the excellent presentation that Christoph Busch just gave us on Articles 5 to 8. Article 5. And I'm going to discuss Article 6 to 9. And as you will see, these provisions follow up on the limited liability of platforms and focus on the enforcement and compliance through supervisory regimes. That is something that I believe characterizes the Digital Services Act, and that can be seen as a missed opportunity. Now, I will say a little bit by means of introduction and then explain Articles 6 and 7 in more detail and say a few words about Articles 8 and 9 as they relate to supervision and enforcement. Let me just see if I can go to the next slide. So the starting point of the Digital Services Act is, like Christoph Busch explained, to maintain the regime of the e-commerce directive. So to have a very limited liability for platforms under the host exemption if they are providers of information services. But what the DSA adds to that is that it seeks to encourage platforms to monitor voluntarily what is happening on their platforms. So the idea is that platforms should not be afraid of liability, but voluntarily be willing to monitor what information is published. And that seems to fit very well with the idea of platforms as open spaces for discussion and sharing of information. And so with free speech and social media platforms like Facebook, only with a limitation where fundamental rights are being infringed. And so the idea that platforms should be actively monitoring whether adverts, for example, have an influence on election outcomes, or whether there are statements on the platform that could be qualified as hate speech. But it doesn't go further than that. And so one of the main questions that I would want to put on the table is whether the approach that the DSA takes goes far enough for protecting the economic rights of consumers and business users of platforms. One other point to mention here as a preliminary point is that the DSA also encourages the use of technology by platforms to monitor what content is being posted on their platforms. But as we shall see, it also creates new questions as to the extent to which technology can be used. Let me now focus on Articles 6 and 7, so the specific text, and explain what they add. Article 6, which was already referred to by Christoph Busch, is in effect a Good Samaritan provision that confirms to platforms that if they voluntarily monitor the content on their platform, they are not at risk of liability. That seemed to be a concern for online platforms, that they would lose the host exemption if they actively voluntarily started searching for illegal content. Now, this provision clarifies that that's not the case, and the inspiration for that might have been the US provision on a Good Samaritan rule that already said something to similar effect. And one could indeed see that as encouraging if one accepts that liability has any effect at all on the behavior of platforms. Of course, empirical studies could provide us with more details on that. Generally speaking, if we look at liability laws around the world, there have been empirical studies on whether liability rules have an effect on behavior, for example, of medical doctors. And some studies show that there is an effect and some show that there is not. So perhaps this is not the most effective tool, and that could also explain why the DSA focuses more on the supervision by authorities rather than on liability rules. At the same time, I'm not saying that that's the right approach, because we do have a gap then when it comes to protecting consumers and business users of platforms who suffer actual damages. Now, as a general point, what we see here is that the DSA seeks to balance different rights, what I already said, and I want you to bear that in mind when we go to the next point. Is this given in by the protection of free speech, Or can this approach also be applied to online marketplaces, as the DSA claims to be applicable to all types of platforms? And perhaps one of the most interesting provisions in the part that has been assigned to me is Article 7, which copies the e-commerce provision on monitoring, but with a slight modification in the wording. So this provision says that there's no general obligation to monitor the information on platform websites. And that, of course, fits with the overall picture in which the host exemption is central. Nor there can also be no active obligation to seek facts or circumstances indicating illegal content. And here it becomes interesting, and I thank Christoph Busch for pointing out this article by Daniel Holznagel, who identified a difference in the wording between the e-commerce directive and the DSA, and as an in-between the decision of the Court of Justice in the famous Glasvishnik Facebook case. What we see is that the e-commerce directive indicated that there's no general obligation to monitor, nor a general obligation actively to seek facts. And that word general applies to both elements, so an obligation to monitor and an obligation actively to seek facts. Now, in the Facebook case and in the DSA, that wording has subtly changed to use the word general only to reflect or only to apply to the obligation to monitor the information, but no longer to the other part, to actively seek facts or circumstances. And applied to an actual case, we can think of using technology that can filter specific information on platforms. And many online platforms do use algorithms and automated filters to search through their content. Now, you could use such filters to search for specific information, so monitoring specific, not general obligation. But what if there are false positives? You can't, under these new rules, if you take them literally, oblige a platform to manually then do a check for specific outcomes of this general filter and to weed out false positives. So that would mean that there's only you can only oblige a platform to use an automated filter if it gives only good outcomes and no false positives. That is if you take it literally. But the question then is, of course, does the DSA really intend to have this effect? I think we don't know that on the basis of the text currently. If we look at national cases, then we see that under the e-commerce directive, they wouldn't have a problem with obliging platforms to search for specific information and to do a manual check afterwards for false positives. But perhaps the Glasvishnik case and now the DSA have changed that approach. Then to follow up on this, on the provisions of Article 6 and 7, so they deal with the position of the platform and their own voluntary actions, plus to what extent they can be obliged to monitor specific information and content. In addition, the DSA prescribes in Articles 8 and 9 that supervisory authorities have a role in seeking enforcement and compliance of these rules. I'm not going to discuss those provisions in detail. You can read them for yourself. I think what is interesting is that we see here that certain competences are given to digital services coordinators at the national level. And that fits with an approach that we have seen in other contexts for the collective protection of consumer rights. For example, that many member states have authorities for consumer protection, sometimes combined with competition law enforcement, and that they have competences, for example, to impose fines on businesses that infringe consumer rights. Now, who are those digital services coordinators going to be in case of the Digital Services Act? If we follow the proposal, we're looking at national entities that are going to be designated by a member state, and they could well be existing authorities. In fact, I would think that most member states would choose that option as it is the most efficient and least cost effective. So it could well be in the Netherlands that the Dutch Authority for Consumers and Markets will be the Digital Services Coordinator. And that means that this authority gets these additional competences under Articles 8 and 9 on top of other competences that they already have. And there are many. I don't want to highlight all of them, just want to take one that is part of EU law and that could potentially be very important in practice when it comes to enforcing consumer rights compliance by online platforms. And that is a provision of the CPC regulation of 2017, Article 9, which gives authorities the competence to, in certain circumstances, take down websites that have posted illegal content. Now that is a big step. When you think of that in a freedom of speech context, that is sort of the greatest limitation that you can put on free speech, taking down the entire website. And therefore this competence comes with quite a lot of restrictions and additional requirements. So it can only be imposed in cases where it is thought to be the final remedy when everything else has failed and when it is deemed proportionate. In the Netherlands, the proportionality part needs to be tested by a judge before this action is given effect. I think that seems fair. So you have an administrative authority that has competences to impose certain sanctions, but for a sanction with this effect, a judge has to evaluate the sanction before it is actually given effect. Now, quite a strong sanction already, and of course the DSA says that it applies without prejudice to existing regulation, also to this regulation. It's mentioned in recital 30. But the question that I would have then is, what does this mean for the practice of supervisory authorities? So an authority like the ACM in the Netherlands might get the additional competences on the basis of the DSA, but it already has this competence. So what we're seeing is a greater dispersion of competences which may apply to different entities. Of course, the CPC is meant to protect the interests of consumers, whereas the DSA applies to users or recipients of a service and could therefore have a different scope of application. Doesn't make it a whole lot easier for the authorities and for the users to see under which scheme they fall. So to conclude, what we see in the DSA, the provisions dealing with voluntary compliance and enforcement through supervision is sort of a two-pronged approach. On the one hand, there's a big focus on supervision and administrative schemes that encourage platforms to build in their own measures of control for the content that is being posted. On the other hand, that is voluntary for the most part. The DSA seeks to encourage platforms and not to scare them off with liability. But that means that there is a gap and there are parts missing for consumer and business users, and in particular for consumers perhaps. Of course, it's great that there's ex-ante control, but what if they do suffer damages as a result of illegal content posted on a platform? Do they have rights or actions? I would have more to say on that, but my presentation, well, that question is slightly outside the scope of my presentation. I'm writing a piece with Christoph that will appear in EUCML very soon, and I will discuss the question there as to what individual remedies consumers have and what the DSA means for that scheme. And I'm going to leave you with the question, does the approach proposed here go far enough, in particular when we look at online marketplaces instead of social media platforms? Thank you.
Thank you very much, Professor Mark. I will just pick up this question and refer it to our commentator, Jan Penfrat, who I think also prepared some comments for the two speakers. If you could just deactivate your presentation. Thank you. So the floor is yours, Jan.
Thank you very much. Thank you so much for having me. It's a pleasure to be here. Thanks also to both Professor Busch and Professor Mark for your presentations. Very interesting. Now I have this slight advantage of being here not only as a neutral legal observer, but as a human rights advocate, digital rights advocate to be precise. And so, I'm looking very much at these laws from a perspective of the protection of fundamental rights and what the impact of the Digital Services Act proposal is going to be on people's fundamental rights online. Now, with a lot of what both of you have said, I would agree. So I think it's very interesting that both of you have chosen to present this in a direct comparison to current law, namely the e-commerce directive. I think that's a very good approach because it shows that the Commission has indeed been relatively careful in trying to reword provisions that have proven to work more or less over the past 2 decades. And that's particularly true for the intermediary liability regime, but I guess also for some of the other provisions. And a lot of those provisions have also had a positive impact on the protection of fundamental rights online, including the liability exemption, the prohibition of general monitoring obligations that have already been mentioned. And I would even go a bit further. Some of the new provisions the Commission has proposed in the Digital Services Act are also actually relatively good. In terms of, for users, for the protection of user rights. And I guess, what I can mention here is 2 of them that have already been discussed, which is the general differentiation between marketplaces on the one hand and content hosting platforms on the other, which makes sense because regulating product sales online has a different impact on, for example, the freedom of expression than regulating, for example, speech on social media. So I think that makes a lot of sense. The same is probably true for things like the Good Samaritan approach, which is also, in my opinion, very carefully worded. So it makes sense to include this there. As long as this isn't used to, as kind of a general approach to push platforms towards more policing of speech than they would otherwise do. And maybe another point that I quickly want to mention, because it was also brought up by both speakers, I believe, that's the Know Your Business Customer provision, which I believe is a very interesting approach to push some of the liability towards platforms in case they don't fulfill what I would agree with the speakers is a kind of reasonable expectations on consumer side to say, I have to understand where, from whom I'm actually buying a given product. So these are particular rules that work for marketplaces, but obviously we need to be careful in this regard to not expand then during the legislative process those rules towards other kinds of content. And many of you will know that there have been in the past regular attempts to legislate against what many call online anonymity, even though I often refer to it more as pseudonymity online. And so it would be easy. I could easily imagine as part of the legislative process that in this KYBC provision that the B just disappears and it becomes a general know your customer provision. And I know that many in parts of the political spectrum would like to see this. And in fact, some in the German government have just put forward or planned to put forward another push into that direction, kind of de-anonymizing many of the users on social media. With the same goal, right? Increasing the liability of people and then eventually of platforms in this context. Now, there's one interesting bit which I also want to mention in my role as commentator in the few minutes that I've left. We've spoken about the intermediary liability regime and you know how the DSA has taken on most of what has been law already now under the e-commerce directive. There's one piece which I find disturbing, which isn't embedded directly in Article 5, but is directly linked to it. It's true that the Commission proposal doesn't change much the definition of actual knowledge in Article 5, which, you know, if you have actual knowledge, then that triggers platform liability. But there is another provision embedded in Article 14, paragraph 3, which regulates the notice and action system. So basically a mandatory system for platforms that would allow users to flag potentially illegal content on those platforms. And so this paragraph 3 of Article 14 basically says that as soon as a platform receives a notification, that constitutes actual knowledge and therefore triggers intermediary liability. And now from a fundamental rights perspective, that is an incredibly worrying provision, because what kind of choice does a platform has in that scenario? They can say, well, we do a legal assessment for every single piece of content that is flagged to us, and we have a specific lawyer looking at it, or hundreds of lawyers looking at this, and then we may be right or may be wrong in our assessment. That's a liability risk that they take as commercial enterprises. Or alternatively, they can just remove the content just in case, be done with the liability risk, and if later the uploader or the provider of the content complains, then that's, you know, then they can think about it again. So internally, I already call this the delete first, think later approach. And it's a real pity that the Commission has put this in, because it undermines the otherwise very well worded Article 5 and the other provisions around the liability regime unnecessarily. So just to add this as another comment on top of this, otherwise I'm very grateful for the presentations. That was very informative even for me. Thank you.
Thank you, Jan, for your thoughts, for sharing your thoughts. Does anyone of the speakers want to react to Jan's term, delete first, think later? If not, then I would, Professor Mack, yeah.
I would just like to say one thing. I very much like that comment. Thank you for that. And I think it's an important comment. In particular for the practice that we're going to expect from online platforms. So besides what obligations can be put on platforms under Article 7, where you can also ask to what extent a platform should be allowed to use a system where you have false positives and then also take down information that might have been perfectly fine. This is a similar situation where you would choose an approach where you delete illegal content or flagged illegal content that might in the end turn out to be fine. And I think it's a very difficult question, as we see that platforms that use filters do try to use them in a correct manner, but the technology is not always sufficiently developed to give us only good results, so only results that are actually flagging up illegal content.
Yes, Professor Busch.
I may quickly react. Thank you, Jan Penfrat, for raising this very important point. I was wondering, would it be a solution if this provision would be limited just to trusted flaggers, where the risk of false positives or even, let's say, malicious notices, bad faith notices would be lower, would be reduced? Would that be an acceptable solution?
Thanks very much. That's actually an interesting idea I haven't thought of yet. That may limit the problems a little bit with this kind of approach. I would, however, point to a related but different problem in the provision on trusted flaggers, which is that although the provision of trusted flaggers is very positive in the sense that it does involve, like, the trusted flagger status will be awarded under this proposal by the digital services coordinator. So there is some protection, a kind of pre-selection of who can be a trusted flagger. So that's a good sign. But the law itself, or the proposal itself, doesn't give any limits as to who can be awarded that status. And so if we look in jurisdictions where the trusted flaggers have been working a lot already and are actually closely cooperating with platforms, and I'm eyeing the US here in particular under the DCMA, I think that's the right abbreviation, or DMCA. Where it's mostly about copyright law, so it's a little bit a different field. But there we see that the close cooperation between copyright rights holders on the one hand and platforms on the others leads to a situation where basically the platforms just say yes to everything that comes, even though it's clear that the rights holders themselves are they have an inherent interest in content removal. They don't care so much about over removal. They want as much as possible removed of anything that could potentially infringe their rights. And that again has a tendency to lead to over removal. So I'm not sure if that as an only protection would solve it alone. Now, if I'd have to give an idea or a proposal on how to do this better, my argument would always be that the only convincing reason for me to transfer liability for user content to a platform is if the illegality of a given piece of content has already been determined by a competent authority in a member state. That could be, depending on national law, could be a court, of course, a court decision. It could be an administrative authority if that's the national law. And I admit that this is obviously an approach that sets a very high bar for platform liability for online content, but it also acknowledges that the primary responsibility for illegal content is with the person who has created that content. And again, people are not anonymous online, not even today. They're mostly pseudonymous. And so with the data that is available on, in telecoms companies and at the platform level themselves, if the content is really that bad that you need proceedings, well, go after the people, get them. Yes, that needs resources in the judiciary, that needs better equipment of the courts and of the prosecutors. That's true, but there is no easy way out to get justice. There is no shortcut via the platforms. And that's my opinion. Thank you.
Thank you very much, Jan, for your thoughts. If there are no further comments by the speakers, I would open up the discussion and read the questions that have arisen in the question and answer section. The first one is addressed at Professor Busch, I assume, and it asks whether the wording average and reasonably well-informed consumer raises the consumer benchmark, as average consumer by default implies a reasonably well-informed consumer.
That's a very valid point, and indeed it's a bit strange that the article uses this terminology, this wording here. You would expect the reasonably well-informed, reasonably observant and circumspect consumer or something like this. This is, I also have the impression that that's a new formulation that we see here, but maybe that's just a drafting issue. I wouldn't suspect that this is meant to raise the bar. Probably this will be ironed out in the legislative process. That would be my hunch.
Thanks for your answer. Moving on to the next question. Sorry.
Sorry.
Professor Mark again. Also, I'm sorry.
Yes, now if I may comment on this too, I wonder, I think the wording of this provision actually fits very well with the way that the average consumer has been defined in the case law of the Court of Justice and then codified in the Unfair Commercial Practices Directive, for example. And it's now seen as the concept that applies throughout EU consumer law when it comes to transparency and information obligations. But I read the question as such, and if I read it correctly, that it is a very high bar, and I would agree with that. And Christoph already made the point that, well, the UCPD also has a category of vulnerable consumers. So perhaps the DSAs should also acknowledge that there are consumers who don't fit within this category and protect them as such. And I think that would be a very good addition.
Thank you. Jan, do you also have a view on this? Okay, thank you. Then we move on to the next question. It's a live question by Christoph Gerner. I will give him permission to speak now. I think it should work now. So Christoph Gerner, if you want to ask your question, I think you need to unmute and then you can ask the speakers your question.
Do you hear me now?
Yes.
Yes, it was just a misclick. I don't know why. Sorry.
Okay.
Thank you for the presentations. Very interesting, but no question from my side. Sorry.
Okay, thank you. Then we will move on. We have further questions in the Q&A section. One from Jorge Moraes Cavallo, who asked that according to recital 23 of the directive of the sale of goods, member states are free to extend the application of the directive to platform providers that are not considered sellers under the directive. Do you think that Article 5, paragraph 3 of the DSA restricts this freedom? Who of the panelists wants to go first?
I'm happy to say something about that. And George, thank you for your question. I can't see you, but nice to know that you're here. I would say it doesn't necessarily restrict the approach in Waterlet, but the question is really what remedies consumers have already under the Consumer Rights Directive, the UCPD, and so on. And if I look at it, then the Consumer Rights Directive and the New Sales Directive are the ones that extend the remedies the furthest. And Waterlet is, of course, a case that was a catalyst in that respect. But I would say it's actually quite normal for existing EU law that consumer remedies towards platforms are very limited. If we look at the Omnibus Directive, it introduces some new obligations for platforms, for example, in relation to information that reveals the status of the trader. A consumer needs to be informed whether they are dealing with a professional trader or not. And it is said that this is, so that's under the Consumer Rights Directive, and then it is said that this is essential information that if it's not given would be an omission under the Unfair Commercial Practices Directive. But I find this a very interesting point. UCPD is seen here as the directive that should provide a sanction, but the sanctions are not harmonized. So the original UCPD of 2005 provided that there needed to be remedies, and it said something about having those remedies in individual actions or collective actions, but it left it to the member states to decide what to do. And Article 11A of the Omnibus, introduced by the Omnibus Directive in the UCPD, also leaves it to the member states. It only says, well, I don't have the provision here, so excuse me if the wording is not completely correct. It says that member states should provide individual remedies, such as termination, price reduction, etc. But it is left to them to determine under what conditions and what effect those remedies should have. So there's still a lot of leeway, and I think, George, the answer to your question is that it depends on national law. I don't think the Omnibus Directive has harmonized that completely, and I don't think the DSA is making a difference in this respect. In my opinion, that's a missed opportunity for the DSA.
Thank you very much for this extensive answer. We have another hand raised from Jacques Le Chevalier. I will allow you to speak now. So you should now be able to address your question to the speakers.
Yeah, apologies, this was a mistake, but I'm thinking of questions right now. Apologies for this.
Okay, thank you very much. Then we have another question from Rania Vasir, who asked, to which extent are platforms that engage in micro-targeting of users or content promotion are exempted from liability according to Article 3, paragraph 1? Professor Busch, if you want to go first.
I'm not so sure whether Article 3, paragraph 1 would be my first port of call in such a case, because that would require, let's say, a transmission service, information transmission service provider, like an access, internet access provider. The DSA contains other provisions regarding targeted marketing, transparency provisions, but I couldn't think at the moment about any specific rule in the liability chapter regarding micro-targeting, but I would have to think about that.
Thank you very much. And then we have another question by Lucas Gottschammer addressed to Jan Penfrat. He states that he understands Article 14, paragraph 3 to make sure that the notice system has to be set up effectively, in a sense that the platforms make certain the information reaches relevant people to deal with it. A platform cannot say, we did not know of the content even though we received the notification. After that, they have to deal with it expendiously. Would you generally prefer platforms to have a longer time to react to minimize the risk of overblocking?
Thanks a lot. That's a really good question. I don't think that the lack of time is really the issue that leads to overblocking. That may be the case if you look at proposals such as the online terrorist content regulation in the EU, where the timeframes have been incredibly short, like go down to 1 hour or 24 hours or something like that. Then that may create additional incentives to overblocking. But the situation we're in here is that platforms have an incentive under these kind of proposals, not because the time is too short to assess any given piece of content, but because the amount of content that they will have to assess is just too large. So if you're a platform even as big as Facebook or Twitter, or Facebook being in a different league than Twitter even, then you will have probably tens of thousands or hundreds of thousands of notifications per day, maybe. And so assessing all of this in a legally sound way is literally impossible, which is why they will revert to automated means of scanning. And as has already been mentioned, I think everybody who has studied this automated means knows of the shortcomings of those means. And so there's no easy way for them to do this, and commercially it's not viable. There's no commercial reason for them to actually do this kind of legality assessment right. And so the only reasonable thing for them to do is suspend it, unless obviously, and there's also a provision in the DSA proposal about this, unless a notification is obvious nonsense or doesn't fulfill the formal requirements that are specified in the DSA proposal. But those, I think those are easy to comply with for any notifier. So it opens the door pretty wide for an abuse of the system to take down content that you don't like. And I would expect that if this becomes law, a lot of people will start to make use of this especially people who have very narrow views of what should or should not be allowed to be said on the internet.
Do any of the other speakers want also share the views on this question? As we have still some time, I think there might be feasible. If not, then we have another question to Jan Penfrat regarding the balancing of the fundamental right to freedom of expression against other fundamental rights that might be affected by hate speech. The first question is, to what extent do you think fundamental rights are applicable to private platforms? And the second one would be, how can opposing fundamental rights be reconciled by application of content moderation systems?
This is a very difficult one, because obviously, yes, there is a balancing act. So we're not only talking about the fundamental rights for freedom of expression of those who want to say whatever they want on Facebook, right? We also talk about the fundamental rights of people to actually access information online, which may be seriously impeded if anytime you go online, you're immediately harassed into silence by a bunch of trolls online. So yes, this is a huge problem, and getting this right is difficult for anybody. It would be difficult for courts. It is difficult for platforms to get this right. But I think what makes this, I think it's important for us to realize, to recognize that that hate isn't something that the internet has created. There were hateful people before. Now we've given them a megaphone, right? So that's for sure. But it's not like the internet has created hate or racism, for that matter, or other social problems. And why do I mention this? Not to make this problem look smaller, but I mentioned this because it's important to recognize that there is only so much that internet regulation can do to solve the underlying social problems that we are seeing exacerbated by this kind of technology. And so if you want to kind of reduce the overall negative impact that this kind of online behavior has on us as individuals, but also on us as societies, then I think rather than trying to look into better ways how to delete stuff, I think it will probably be more successful for us to look into whether we can change the way the online ecosystem works today. Because what is happening is that what we've started to do is that the whole public debate that we're having is happening on basically 1 or 2 or maximum 3 privately held huge mega platforms with billions of people on it. And that obviously gives a huge space for spreading hate speech. And what's worse, those platforms are working with a business model that profits from the spread often of this kind of information. And as long as that's the case, no matter how great our deletion policies are, we're not gonna solve the problem of hate speech or others that affect people online. So I think we should be looking into those structural problems in the centralized platform economy today, trying to diversify the platform economy, give people an actual choice on which kind of platforms they want to be, under which kind of moderation rules they would like to live online. All of these things are freedoms that people don't have right now, and that's why we basically, as users, have no way to protect ourselves on these big platforms today. So that was a little bit long.
No worries, we have enough time still left. And there's another question on content moderation, actually, raised by Nicholas Forgo, who mentions a recent case where an editor of an Austrian newspaper published an email that was sent to her full of hate speech. And the outcome was that this posting was then deleted. And Nicholas Forgo wants to ask how a platform should deal with this under the regime of the Digital Services Act. It was primarily addressed at Jan, but of course, all the other speakers are also welcome to share their thoughts on this case. Maybe I give the floor now to Jan, since it was addressed to you first, and then let's see if Professor Mark or Professor Busch have some further comments.
Thanks. Given that I've had the floor for a lot and that I don't know the case very well, if any of the others want to jump in first, don't hesitate.
Yeah, perhaps as a general comment, Jan, thank you for your explanation. You are clearly the expert on this panel on the fundamental rights part. So perhaps more as a general comment than on this particular case. One difficulty that the DSA has also not solved is what type of content should platforms be able to delete, or what should be considered illegal content. And there were documents before the DSA was published that said that this definition would also be reassessed. And is illegal content perhaps too narrow, because there are many forms of content that are not illegal as such, but that somehow spread disinformation and influence the public debate. And so this part has not been solved, and I think that is an essential element of content moderation, and it also sets the scope within which content can be considered illegal and should be deleted. So to my mind, the DSA does not solve that. I know that's not an answer to this specific question, but I do think it's a problem. And if I may, then I can perhaps pose this question to Jan as to what your thoughts are on this, and whether the DSA proposal should be amended on this point.
If I may jump in, or would you like to respond directly?
Go ahead, I can do later.
Okay. I just wanted to add that the case mentioned by Nicolas Forgo nicely shows that it's to a large extent about context, and whether you have a posting that merits to be taken down or not. How can you talk about hate speech without quoting to a certain extent some elements of the hateful message, and then even then it's a difficult decision whether to quote, whether to fully quote. So let's say conversation about the topic of hate speech may involve references to hate speech, and I think this contextual element is very difficult, especially for automated content moderation, to grasp. So I think that's an almost unsolvable problem. So since I think it can't be solved, let's say ex ante, I would say it is necessary to have procedural safeguards for such a case. That if something is taken down, that it's possible to get it back up. It would be a similar situation with products that have been product listings that have been taken down erroneously. It is necessary to have procedural safeguards here, and I think in that direction the DSA does bring some good elements.
Yeah, if I may, I couldn't agree more. I think especially the proposal in the DSA to establish what they call out-of-court settlement mechanisms, where people have an easier to access way to get remedies, to get redress for potentially wrongful content decisions taken by platforms. I think this is one of the approaches that is needed to allow people to challenge decisions that are taken by platforms. Sometimes in our community, where there is a lot of people who are worried about over removal of content and overreach of these kind of policies, the counter reaction then is to say, shouldn't platforms be forced to host everything that is legal? We call this a must carry rule. Wouldn't that be the right response to things? And I don't think that would be right either, because what we would create is an internet where every platform is the same, and people would have to accept a whole lot of crap, if I may say so, that is is still legal, but is still you may prefer not to look at all day. And so again, I think as long as there is no way that one single unified platform that hosts 3 billion people on the planet will be able to come up with a set of content moderation rules that will work for everybody. That's not possible, I think. Even if they did the best job possible, which clearly they don't, but even if they did, then they would probably fail. So what we really should be aiming at, and some of the provisions in the DMA try to look into this direction, there could be some things in the DSA that could make that happen, is diversify the offer in platforms that there is. Give people a choice. There are some people, mostly technologists, who are even talking about, wouldn't it be possible to disintegrate, kind of to disconnect the core service of a platform from the ancillary service of content moderation? So give people the choice on Facebook to use the content moderation algorithm that fits their needs and their preferences, and plug it onto Facebook, either server-side or client-side. Both would work. I guess client-side would be easier to implement. And that way also create a new market, you know, on the go. That would create a competition between different models of content moderation. And you know, we could build and improve this together through innovation. All of this isn't happening right now. We're just sitting there looking at Facebook to do it right and waiting and hoping that their innovative power is somehow enough. And on the way, starting to believe that Facebook is somehow the uncircumventable public infrastructure that they actually would love to be, because that way they could stay on for a very long time to come.
If I may add one thing, there's a very good proposal on what you just described by a group around Francis Fukuyama from Stanford, who just suggested such a type of new middleware, as they call it. Let's say a custom filtering level or custom content moderation level, so that you could have a university or an NGO filter the content on Facebook because you trust this filtering intermediary. Yeah.
Thank you for this very interesting exchange on content moderation. And I think it's clear from this discussion that content moderation is actually one of the main problems when it comes to internet intermediaries. I would now wrap up this session and thank all of the speakers once again, and also our commentator. It was a very interesting session to moderate, and I hope you all also enjoyed it as much as I did. I will now hand over to session 3, which is moderated by my colleague Jakob Jürgen-Liller. Goodbye.